Okay, we're back. We're to page 9, objection 5, 6, 7, and 8. You may proceed, Dr. O'Connor.
Thank you, Your Honor. I think we were just covering at that point the Palmer standard in that case law. But going forward into page 11, if we may, Your Honor, essentially under the section of domestic relations, essentially notices and objections relating to uh, non-discrimination between married and unmarried couples, that regardless of the situation, it may not allow the state to step in to determine child or make child custody determinations or parent-child associations, regardless of the marital choices that people make. And they cite Semblocki versus Redtail. Moving forward under page 12, in terms of First Amendment protections that involve not only parent-to-parent communication, but parent-to-child communication, that predisposed custody orders actually limit First Amendment protections between the child and the parent, and is cited in Meyer, Nebraska, and Wisconsin Yoder. The same type of custody, moving on to page 14, and I'm trying to paraphrase as efficiently as possible, Your Honor.
Thank you.
I appreciate it. Anytime there is a custody order, of course, it's going to put restraints on one or both parents in terms of association with the child, and inversely of the child with any of the parents, and is cited in Packingham versus North Carolina. In terms of going to page 16, censorship, which is related to prior restraints, there is censorship that occurs. It's unconstitutional that there is censorship, because anytime there's a custody order between a child and a parent, it censors the ability of the child to associate, to have intimate association and identity with the parent, and vice versa. The state's purpose, going to page 19, very briefly, as you know, is to protect the individual fundamental rights, not only of individuals, but also of the child, who is well an individual, and to protect the rights of association, to protect due process in a legitimate fashion, and that the best interest doctrine of the child does not outweigh that. As the judiciary is operating under the assumption of the best interest of the child, that can put the judiciary in a biased position rather than a non-biased position. Moving on to page 22, very briefly, the petitioner asked the court to make notice of SCOTUS's ruling regarding Matthew balancing test, in that is there a private interest that is affected by the official action or potential official action? Is there risk of erroneous deprivation of such interest just by mistake? And is the government interest far outweighing the previous two stipulations, in better words? Briefly going to page 24.
Mr. O'Connor, Dr. O'Connor, I need you to repeat. I couldn't hear. And is the government interest far outweighing? And I couldn't hear after that.
Oh, does the government interest far outweigh the individual interest? In page 24, just discussing briefly adjudication rights. Each parent enters proceedings with equal rights to the same child, and they seek to exercise those rights equally but independently. The child can't assert their own rights. They don't have the ability to, and the child's not a party nor a litigant. The Constitution presumes that we're fit parents from the get-go, and that is upheld by SCOTUS. And they refer to Troxel Cranville case as well. Briefly going forward,
But
just
before you,
taking judicial notice of, yes, sir.
Doctor, so although you have not specifically pled for it, is it your assertion that the court should, in this case, appoint a guardian ad litem or a attorney ad litem to represent the interest of the child?
No, sir, it's not my assertion.
Okay, thank you. You may proceed.
Yes, sir. Yes, sir. And then just moving forward briefly to the conclusionary pages in page 27. Individuals have rights. The parents have rights. They're equal rights. They have rights of association, rights of due process, rights of protection for themselves as well as for the child. There are, moving forward to page 28 and 29, objections to existing state statutes, of course, and what is cited is Reno v. Flores from the Supreme Court, and moving down and concluding basically that the petitioner asked the court to take judicial notice that the petitioner made an intimate, private, and constitutionally protected choice to be a parent, that being a parent is a massive element to any parent's personal identity, that to take judicial notice of the intimacy of daily activity between a parent and a child, to take notice that the respondent's children, in guiding and directing respondents' children and developing the children's own concept of personhood and individuality is an essential element of a parent's identity, not just the petitioner. And I would conclude with that, Your Honor, essentially that the Constitution applies to the individual rights of parents and children. And I think I will rest my petition right there. Except on the last page, I believe the petitioner should be afforded, and what the relief I'm requesting is that should be afforded full, substantive, and procedural and equal protection of petitioner and petitioner's child, fundamental rights, that the courts affirmatively determine what process is due given the unique conditions in the case, and apply the procedural protections necessary to protect substantive rights implicated in any proceeding. And I believe the court should grant all declaratory relief. And I'll conclude that, Your Honor.